We're on the record of the people of the state of Michigan versus Shepard Hopstead, file 21-0375 SM. Counsel, identify yourselves for the record.
Thank you, Patrick Swinsky for the people.
John M. English and the Kronzek firm on behalf of Mr. Homstead at this point. Good afternoon, Your Honor.
Good afternoon. Today's time and date set for motion filed by Mr. English. Actually, it was signed by him and his client in order for him to no longer be the attorney of record, wishes to no longer to be the attorney of record. So I had a few questions prior to that, Mr. English. The case here was your client was originally charged on March 30th of this year. He was appointed an attorney on March 31st. Mr. Lee Burton was the attorney who filed an appearance on April 5th. On April 19th, you filed a substitution of counsel. There was a pretrial scheduled the next day on April 20th, and my notes reflect that a spouse abuse deferral outside of a dismissal, probably the most probable outcome for many domestic violence cases, was offered. Did a pretrial on May 11th. At that time, set a jury trial for July 29th and a status conference for July 27th. On June 30th, you sent a note in asking to be relieved from service. And I'm trying to determine under the rules of professional responsibility which paragraph you're relying on.
Well, I'm not sure if I could go back. Well, what's the court's question? I'm unclear on Your Honor's question.
Sure. Is that he had a court-appointed attorney. You got involved in the case. You should have known or anticipated that the offer, which was spouse abuse deferral, that would probably end in trial. Now you're saying you want out just because you didn't get paid. I'm wondering why you didn't contemplate that up ahead of time so that we're less than 2 weeks out, and now you want to get out of the case because you didn't get paid. Why didn't you consider that up front?
Well, okay, we're on the record here. If I may, Your Honor, I'll answer the court's question as best as I can. First, I didn't file a motion. I filed a stipulated order, which was proposed for Your Honor's consideration.
It wasn't signed. The stipulated order was not signed by the prosecuting attorney. It was only between you and your client, correct?
Yes, the stipulation says.
Yeah, go ahead.
I'm sorry. The stipulation says by agreement of defendant and defense counsel and with permission of the court. And a copy, of course, was sent to the prosecuting attorney. In case the record isn't clear about that, that was provided to the prosecuting attorney when I sent it to the court. And I don't believe I sent any note to the court. I think what I sent was a proposed for the court's consideration, a stipulated order of agreement where I copied the prosecutor between myself and Mr. Homstead. Your Honor, that to try to address the court's concerns here, I take that the court's recitation of the events is all accurate. In terms of when I entered the case, I'm happy to go into as much detail as the court asks me to. In this case, like in all cases in our firm, we quote an amount of attorney fees, which is what we did in this case, I'll say. There's a contract. The contract states, and in this case, Mr. Homstead, I think, will agree that he understood that the quoted attorney fees exclude trial and trial preparation. I accept for the record that I substituted in on April 19th and that there was an offer of $769 for a status, which I agree with the court's characterization that that's often the best disposition that could occur in one of these type of domestic assault allegations. And this is a first offense as far as I'm aware of it. I mean, Obviously, as the court is aware, I'm constrained up to a point by attorney-client confidentiality, but I think it's fair to say that my client from the get-go, even before I formally filed my appearance and the firm's appearance, what was under consideration was a trial. In other words, consistent with, I assume he entered a plea if not guilty to the charge, that a trial was contemplated initially. That being said, though, the contract and the way this firm does those things, and it did not differ with Mr. Homstead, we initially quote a fee, and then assuming the case, if it does go to trial, and most don't, as Your Honor is aware, then those fees are not involved. Now, this situation is a little unusual for the following reasons, Your Honor, at least from my perspective. And I'll try to be very brief. The allegation involves my client's son. My client's son, my impression is, I haven't double checked his date of birth, but he's either in his young, youthful 20s or late teens. He's not a real small kid. There apparently was a verbal, according to the police reports, there was a verbal altercation that escalated into something, a physical confrontation. And I've discussed this with the prosecuting attorney. And the dispute lies in who instigated the physical altercation. And so I became aware that there were a number of people who claimed that the alleged victim had told them that he started the physical altercation. We provided the prosecuting attorney with the names and the contact info of, I think, 3 people. And to my knowledge, they had an officer speak to each of those people. And I think I received a report to that effect, a supplemental. And I believe that the supplemental, if I recall correctly, had those 3 people, I think, yeah, I have it here, basically reiterating what I told the prosecutor they would say. To wit, son says he started the physical altercation. So I think Mr. Homstead will agree that that information was quickly conveyed, as I said, to the prosecutor. And I think with that information, we kind of thought that likely the charge would be dismissed. Obviously, no guarantee. I also contacted Mr. Zerwinski, and I believe I emailed him. I mean, on May 18th, Your Honor, I emailed Mr. Zerwinski a notice of self-defense. And I'm sorry, I thought I had this at my fingertips. I believe it's early June or June 24th, I had sent Mr. Zerwinski an email asking, are we proceeding with a jury trial or are you dismissing? He responds, I apologize for the lack of communication on this. I handle felony appeals. And that's in response to an email I sent him, I believe, or following an email I sent Mr. Zerwinski on June 11th. I was wondering if you could update me on the status of the case. Are we still moving forward to a jury trial? So the essence of it is, Your Honor, that first, the agreement we had was that the firm would be paid if there was trial preparation and a trial. And Mr. Homstead is unable to do that. Secondly, I have not delayed at all. I have tried to discharge my duties to defend Mr. Homstead, and and provided all that information to the prosecutor, Mr. Zerwinski. And I saw that we were coming up to the trial, and I was quite concerned about that. And so once I heard from Mr. Zerwinski, he said, I've had a chance to speak to your client's son, and I think we can prove the case, so we're going to go forward. I immediately spoke to Mr. Homstead. It was determined pretty quickly. A few business days later, he was unable to pay us. And right away, after obtaining Mr. Homstead's agreement, I submitted a proposed stipulated order to the court. I believe the court was unavailable for the balance of that week. And then we had the 4th of July weekend, and Tuesday is when I think that proposed stipulated order was first placed in front of Your Honor.
Right.
That's the factual situation here.
Okay. So the concern I have is, and let me show you the document. The initial document was signed for a court-appointed attorney for your client. Make sure I got the right one. Hang on. Let's see.
Excuse me.
This is the one. There was no information taken. There's a high probability that I may not grant him a court-appointed attorney if he doesn't qualify. So then he's in a situation where he doesn't have you as his attorney, nor does he have a court-appointed attorney, because he need to qualify in order to make that happen. I don't know if he knew that when he signed the agreement to have you out of the case. So I just wanted to make sure I'm uncertain why we would sign an order allowing a court-appointed attorney with no financial data. But if he once did obtain an attorney, there's at least some concern is that probably shouldn't be afforded a court-appointed attorney. It's not that simple. And I wanted to make sure he understood that if he agrees to release you and I would let you out, because I get it. You had an agreement with him that he would pay. Is that, did he take into consideration he'd be without one or representing himself? And I don't know if he had that information. And so I would be asking him all of those pieces. It's not as simple as him just getting a court-appointed attorney. He has to qualify. So before I sign that order, he may reconsider his position, and I didn't want to have jumping back and forth between who he is going to hire. So if he knows that that's a potential risk, that if I let you out of the case and he's paid you for whatever work you've done already, he may have to start back from ground zero. And we are looking at trial the end of July. High probability that his case would not be first order, because we do have a number of cases that we're working with people who are incarcerated. But I just wanted, before I just all of a sudden sign that, to bring it to his attention that he may not get a court-appointed attorney. If I make the decision, I have to determine his indigency first. So if he knew that with his eyes wide open and made that determination, I'd be glad to sign that order. But I want to make sure he understood he might be in no man's land where he's representing himself, or having to hire a new firm starting from ground zero. So
may I comment on that? I understand the court's concerns fully. Sure. First of all, that's the first I've seen of that form, but given everything that I've discussed with Mr. Homstead up to this point, and after seeing the form that the court just showed me, I would be surprised if I can let him speak for himself. I think it's too bad that the form wasn't filled out and the court wasn't provided with the information that it asked for on the form. I guess I'll leave it at that, Your Honor.
Okay. I just wanted to know. So what I would probably do is that I want to give Mr. Homstead an opportunity, because it makes no sense. If I deny him a court-appointed attorney and he's faced with that situation, now he's got to develop a new relationship with a new lawyer, or figure a way he may qualify. I just don't know. I will be addressing my staff regarding these forms that have zero data in it, appointing an attorney. But that was one of my concerns, was he could be stuck representing himself or having to bring somebody else up to speed, and that actually could cost him more than paying for your services, not knowing and not having to get into the details regarding your fee structure. That's between you and him. But if he realized that those were his choices, he may not want that to happen. So what I think I'll do is, I'm planning on granting your request, but what I would do is wait. I will wait for 2 days to sign the document. In the interim, I'm anticipating Mr. Humpstead submitting a new request that provides his financial information. Where does he work? Is he single, married, divorced, or separated? Does he have enough for me to make a determination? And I will tell you, Mr. English, that you're under no risk, because that trial at the end of July will not be first priority. So I will at least move that date, because I don't want you at a disadvantage, but I also don't want your client all of a sudden to be out and then having to establish a new relationship if he doesn't qualify. So that's so my intentions are to grant your request, but to wait 2 days for him to get the information to me, so that I can make a full determination whether he qualifies.
So if I understand Your Honor correctly, if for any reason, Mr. Homestead, I'm sure, will provide the court with the information the court is requesting within 2 days. If the court makes a determination that Mr. Homestead does not qualify for a court-appointed counsel, am I hearing the court say it's likely that his trial date will not go as scheduled?
Yes. What I'm saying is this: the July 27th, the status conference date will be in place.
Yep.
The July 29th date will not go, because I don't want a new attorney. If I grant your request, a new attorney comes to speed, they're not going to be able to come to speed in 2 weeks for a domestic violence trial. Wouldn't be fair to anyone else. And Mr. Shawinski's office would have to send subpoenas out, or making decisions on sending subpoenas out within the next couple of days.
Sure.
So the July 29th trial, regardless if you stay or if you go, or if he gets a court-appointed attorney, is not going. But in order to keep my thumb on the pulse of the case, the July 27th status conference remains in place. I'm leaving you temporarily as attorney of record, but after 2 days, I will sign an order that you present. I'll sign that order. Today's Monday. I will sign that order Thursday morning, unless you tell me not to, meaning that Mr. Homstead is without an attorney unless they appoint an attorney for him.
Okay, the court will sign the order Thursday a.m. unless I contact the court and say, no, I'm in.
The faster that Mr. Homstead gets me the information, he will know whether he qualifies for a court-appointed attorney. He could submit that to email, or he could bring it down. But I've got, sooner I have it, the better for him to know whether or not I'm granting the court-appointed attorney. So he gets it to my staff, then we can do it. So I'm planning on signing that order, having you out on Thursday. I'm just leaving Mr. Homstead an option, so that he can make an informed decision, because he probably thought, well, I qualified for an attorney the first time, I probably will qualify a second, but I'm not signing an order that's blank with no financial information or any expenses. And so I might not reach that conclusion. So I did not be exposed without having an attorney and have to figure out how to represent himself, or hire new counsel, which would have to retread and read the cases and interview witnesses and all of the stuff that you've already done. Ultimately, it might be more economical for him to pay the retainer fee for the trial, but it's not fair for you to be, having to worry about whether or not the trial is going to go, and it's not fair for the prosecutor to have to subpoena people. So the trial on the July 29th will not go.
Okay.
The conference on July 27th will go, and then I will sign that order that you proposed, that your client signed, on Thursday morning, unless you tell me that you're not. And then I will let the prosecutor know but I will make the independent determination regarding his ability to get a court-appointed attorney based upon his financial need.
Your Honor, is there a form that the court could email him so that he could email that form back to the court? Do you know?
It's the same form. He just needs to put some. He just has to put some meat on the bones. So
Sure.
we could. I could have my staff email if we get an email address. I will have my staff send an email to him with that document.
Mr. Homestead, could you give the court your email address, please?
Yes, I could. Are you ready?
Yes.
It's Hompy76, which is HOMPY 76 at yahoo.com.
Okay.
And I apologize. Go ahead.
That's all right. It just the reason why I had to handle it this way is because of this unique circumstance. So if I had information that says, you know, you're unemployed, you're on disability, then you have a high probability of getting a court-appointed attorney again. But when I have a blank form, and again, it's not blaming anyone. I'm just saying that we processed that paperwork, and there's no information for me to make a decision whether you get a court-appointed attorney. I didn't want you making that decision and me signing that form without you knowing whether you potentially will or have to find the funds. Just because attorneys cost money.
Sorry.
There's value. So you have to make that determination.
Your Honor, I do believe that Mr. Homestead and I both thought that he had qualified for, obviously, in the court's eyes, for court-appointed counsel, and that's why that provision was put in the proposed stipulation. So
he may have they may have taken the information verbally. It just didn't make it to the form.
Right.
So he may have relayed the information. So the magistrate who signed it may have made the right determination, but I can't look at that form in good conscience because we don't have unlimited funds. The county doesn't have unlimited funds to hire people either. They try to save for the truly indigent. He still may qualify, and he may have provided it. It just didn't get onto the form. So I have no way of making that determination. So,
and lastly, Your Honor, if the court ends up signing the order on Thursday, because it doesn't hear from me, and if the court has determined that there will not be a public defender appointed, then I assume the court will strike or draw a line through the last sentence on that stipulated order.
Right, because it would be factually. All right, Mr. Swinski, anything you wish to place on the record?
No, just a correction. Mr. English mostly conveyed the course of this case correctly. The delay was simply waiting for follow-up to be conducted, and then we also had some issues as far as getting the scheduling the victim in for an appointment. But we've been working on this case, frankly. We've been trying to get it resolved, and we just haven't been able to. So that's where we're at.
Okay, but the concern for me wasn't so much the timing, except for within 2 weeks of the trial. The concern was the presumption that he was going to go to court-appointed attorney, and I wasn't certain of that because I didn't have enough information to make the determination. All right, anything else, Mr. English, anything you wish to place on the record?
No, Your Honor.
All right, Mr. Homestead, do you understand the circumstance?
I do, Your Honor.
Okay, all right, well, you should be getting that email this afternoon, and then if you return that quicker the better, with enough information for me to determine. There's a spot in there regarding child custody, child support issues. There's an issue in there regarding finances, savings accounts, that type of thing. We're not asking you to make it like a second tax return, but we need something. I can't just have your name at the top with not even an address and sign that form.
Correct.
We'll be adjourned on this case.
Thank you, Judge.
Thank you, Your Honor.